You know, I'm a maestro and I represent for which FM? Which FM? Really rich FM.
This and Jade Williams, the policy.
The people's champion. Our mission is love. Our vision is love. Jamaicans, for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law.
Happy Tuesday and welcome to Let's Talk Justice. I'm Jade Williams, the Policy and Advocacy Specialist at Jamaica. Alone this week, Mikel is off on travel duties doing JFJ's work in over the Caribbean. I'm not quite sure exactly which part she's gone. But she is busy, so I am here holding down the fort today. And our discussion today will revolve largely around the recently decided Everton Douglas appeal. But before we get into that, we will go through our usual show segment, starting first with our Human Rights Minute of the week. So we have two topics this week. Firstly, the arrival of those Haitian migrants. So around July 10th, 2037, Haitian migrants were assisted to shore by residents of St. Thomas in the Bull Bay area. They were fleeing the persecution from Haiti, and unfortunately, they would have all been charged and convicted of illegal entry in the parish court just last week, I believe. Each person was fined $7,000 and had 3 days of hard labor each. Now, of course, there has been many critiques to this course of action. Some of those critiques came from our board chair, John Clark, who will join us later on for our substantive discussion. But in his comments, he would have pointed out the fact that none of these migrants would have been provided with actual legal representation. And while the Court Administration Division would maintain that they experienced a fair trial, it is questionable when they did not have that representation, how much information they had been given and whether or not they had been given the information necessary for them to undergo an asylum application. Now, following that ruling, we would have also heard from Freedom Imaginaries, a friend of JFJ's run by Malene Alain, attorney at law, that their organization would have filed for asylum for these migrants. And it was indicated by Marcus Goff, another of the attorneys assisting the migrants, that they do intend to stay in Jamaica. When they originally left Haiti, they had no actual destination. They just wanted to escape the persecution, which is perfectly understandable. And in keeping with the UN Refugee Agency, Freedom Imaginaries is bringing an asylum application on their behalf. So we are thankful that Freedom Imaginaries has stepped in this way to assist with maintaining the human rights of these migrants. Now, the second thing that we'll talk about in terms of human rights this week was something extremely concerning, and you can look at our social media pages to see our more official comments on this issue. But the leader of the opposition, Mr. Mark Golding, would have made some comments that it couldn't be described in any other way than voter fraud. He made some comments that indicated that this is something that would be okay going forward into the election, and we, of course, are incensed by that implication. We would have made our public statements asking for clarity, and coming out of that, we would have heard from the leader of the opposition that these comments were supposed to be taken as humorous. Now, while we are going into our election season, we cannot afford to be making humorous comments on what is a serious issue that has plagued us historically. So we ask that in the context of the maintenance of our democracy and in the context of these upcoming elections and what you might be alluding to, that persons are circumspect in their utterances going forward. And we hope to see a complete retraction. The statement that has been made alluding to its humor, we believe is not strong enough. And there must be a stronger indication that this is not something that the party supports. No. That was our Human Rights Minute. I think that was more than a minute. But we'll go straight into our right of the day today, which is more of a did you know? And it is coming from our International Covenant of Civil and Political Rights, and it's Article 2. And that speaks to the fact that each person should have an effective remedy to challenge any breach of their rights or any action that has been a violation of their rights by any person acting in any official capacity. And that the legal system must be competent and be able to demonstrate that competency to ensure that those remedies are enforced when they are granted. And our trivia for today is: what section of the Constitution allows for the calling of a state of public emergency? So what section of the Constitution allows for a state of public emergency to be called? And if you'd like to respond to that, you can send us a WhatsApp at 2397583, or you can respond on our social media pages. The first correct answer will be the winner. Now we go straight into our substantive discussion on Everton Douglas. Now this matter, Everton Douglas and the Attorney General, was a landmark decision in 2020, and it had held that the 5 men who brought the matter had been illegally detained while under a state of emergency. Now, the case further opined that the justification of the use of state of emergency was not in line with the meaning of an emergency under the Constitution and therefore illegitimate. Now, at the time of this decision, the men had been detained for, at the high end, 431 days, and at the lower end, 177 days. And I'll just read an excerpt from paragraph 84 of that original ruling, which states, the return on the writ, which was a writ of habeas corpus, indicates that the petitioner is detained under state of emergency. I hold that this return is deficient, and that for all the reasons indicated by this court hereto, and which include the following: there is no valid state of emergency. The detention at the will of the executive is violative of our Constitution. The detention for criminal offences violates the Emergency Power Act. The Emergency Power Act is inconsistent with the Constitution. The material legislative framework is inapplicable to the material proclamation in this matter. The detention order did not apply the reasonably justifiable test, and the detention is impermissible. Now, 2 important matters would have followed that decision in Everton Douglas, that of Rashane Clark in 2022 and Kurt Mitchell in 2023, which would have received monetary awards of $18 million and $4 million respectively for the breach of their human rights and that illegal detention. So, coming out of Douglas's decision in 2020, the Attorney General, Commissioner of Police, and the Minister of National Security, as joint appellants, challenged the ruling upon appeal on that point of the constitutionality of the state of emergency. So that matter has been decided since July 21st, 2023. So what are the implications of this new decision? What does this mean for the future of SOEs? Are there any key takeaways from the precedent that has been set? So that will be our substantive discussion today, and we will be joined by Attorney at Law John Clark and Attorney at Law Kenyatta Powell. I don't know if either of them are with us right now. Okay, so neither of them are with us right now. So we will just do a quick introductory discussion about a writ of habeas corpus. So habeas corpus is really something that is used when you have a person that has been detained and there is questions about the legitimacy of their detention. And once it is that writ of habeas corpus is brought to the court, habeas corpus really means to produce the body. Once it is that has been brought to the court, it should allow the court to inquire as to the reasoning for that detention. So that is what that initial Everton Douglas case was about, challenging the reasoning for the detention of those 5 defendants. Now, similar reasoning was used in Roshane Clark as well as in Kurt Mitchell's case. And in all of the cases, the awards would have been split by monetary value in terms of who would have been receiving awards for breach versus the breach of illegal detention, so on and so forth. Right, so I'm hoping that one of our guests is with us now. Okay, so unfortunately, we seem to be having some challenges with our guests joining us for the discussion. So I would just do us the favor of summarizing a bit of the initial judgment. I was hoping to have Mr. Clark do that for us, considering he was one of the attorneys that was on the matter, both matters, as a matter of fact. The legalese as much as possible. Okay, so I see Mr. Powell is on with us now. Mr. Powell, can you hear me? I can't hear you.
Hi.
Oh,
afternoon.
Hi. Afternoon. Okay, so I will start with you. I'm hoping you could give our listeners, firstly, an idea of what a writ of habeas corpus is and the effect of it.
Okay, so what I will do is I will start out by saying that I'm going to simplify the legalese as much as possible so that the listeners can understand it. Mm-hmm. So habeas corpus is Latin for you have the body. But what really the writ of habeas corpus is that it's an ancient common law right. And the way the right is exercised is that where a person has been detained, and especially where a person has been detained without charge, the person in a free person in a society has the right to file a writ of habeas corpus. And what the writ is that the writ is a petition to a judge of the higher judiciary, for the judge to bring the person who has been detained before the court, and for the judge to inquire into the legality of the person's detention. And so what it is how it works is that if you have a client who has been detained for an extended period of time without charge, you file a writ of habeas corpus. You petition the court. The court brings before itself your client, and essentially the court summons the person who has detained your client for the person to explain the legal basis on which they have detained your client. So simply that's the process of a habeas corpus, a habeas corpus application. And if the court finds that there is no lawful justification for the detention of the person, the court is empowered to order that the person be released.
Okay, thank you so much for that. So I recall from the initial 2020 judgment in Everton Douglas, we had a challenge. Well, there was somewhat of a challenge about whether or not one judge could hear the application. So I wondered what, if any, procedure is to be followed on these applications for habeas corpus.
Now, you see, that question about whether a judge sitting alone was empowered to consider, and what the question really was whether a judge sitting alone was empowered to consider constitutional. That what some people were arguing, right, is that there is a specific procedural approach to filing a constitutional matter, and I won't get into the nitty-gritty.
Yes, just give me 1 second. Let us take our break really quick, and when you come back, we want you to finish that point, please.
Hi, I'm Ronald Thwaites, and I'm the host of The Public Eye and The Open Mind on The Bridge 99 and Irie Jam in the Tri-State area. This program will tell you the truth about life backyard. Fair, open talk. No gossip, no slander. We want to listen to your concerns. Also want to help you with your problems in JA. We at The Bridge rate you and affirm our oneness as citizens of this blessed land we love. So join us now on Wednesdays on The Bridge, crossing the waters, linking Jamaicans and Jamaican lovers everywhere.
Over 14,000 Jamaicans are living with HIV and not yet on treatment. We want you to know you can live a normal life with HIV. Now is the time to get on treatment. Now is the time to start taking your medication on time, every time. Now is the time for your HIV status to become undetectable. Come to Jamaica AIDS Support for Life. We will help you to reach viral suppression. Now is the time to achieve all your goals and live a long and healthy life. To get on treatment, contact Jamaica AIDS Support for Life at 876-925-0021. A message from Jamaica AIDS Support for Life and the kind support of USAID from the American people.
You know it's national. If you're up on the road or even home, it's always national. National. At church, have a snack at work, little peanut no hurt. Crush crackers in a tea, give me 2 red please. Easy fish here, can carry anywhere. Here or there, no other brand compares, yeah. And if you want something sweet, it's a for unique. It's always national. You know it's national. You know it's always national. Jamaica, born and bred, National Baking Company.
The 2023 Jamaica Festival Song Finals are on.
My name is Sugar, and the name of my song is Dancing Same Way.
In my sweet one love Jamaica, God know it rough sometimes. Can't turn a blind eye, not even pretend that we don't notice the crime. But when festival come around and the radio crank the sound, in the burning heat we still move with feet to enjoy this year festival. Oh, we dancing same.
To vote for Sugar, call or text VOTE to 1-876-444-7705. Votes also accepted on the Reggae Jamaica app.
It's Jamaican, it's Caribbean, to the world on the Bridge 99 FM. You heard?
The people's champion.
Welcome back to Let's Start Justice. We are joined right now by Mr. Kenyatta Powell, attorney at law, and we are discussing Everton Douglas, the beginning, the appeal, all the implications. Before we took the break, Mr. Powell, you were explaining to us the challenge that was raised in the original case, that a single judge could not hear could not rule on constitutional issues. So I'd like you to continue on that point for us, please.
Yes. So it was really a procedural objection. And the objection was that the civil procedure rules of Jamaica set out a specific procedure for how to file a constitutional claim. Mm-hmm. And that procedure in the Everton Douglas case, because it was brought before the court via writ of habeas corpus, was not followed. And so essentially the single judge sitting alone, hearing a habeas corpus application, could not consider the constitutional issues being raised because the case had not been brought under the procedure that would have activated what is referred to often as a constitutional court. Mm-hmm. And what the constitutional court is really 3 judges of the Supreme Court sitting specifically to hear a constitutional claim filed under the relevant portions of the civil procedure rules. And so that was the argument. The argument was that the lawyers for the detained men who had filed this habeas corpus writ was that they hadn't followed the proper procedure and that they were trying to make constitutional claims via habeas corpus application. Mm-hmm. And to me, that line of argument that relied on procedure was always, to me, illogical and misplaced. And I'll tell you why. It is because the detention of the men in question, right,
Yes.
was under various declarations of states of emergency, right? And a state of emergency is a constitutional mechanism.
Right.
So it is the Constitution around Section 20 in the Charter of Fundamental Rights and Freedoms that says that under very specific circumstances, pursuant to a declaration by the Governor General, that the government, the state, can exercise certain powers that they wouldn't be able to exercise because that exercise would violate certain fundamental rights. Specifically, in this case, we're dealing with the right to liberty.
Mm-hmm.
And so what happens is that we have the government, and at that time they had called several states of emergency, and had gotten several extensions in the parliament. And so this is how these men found themselves detained. The man who gave his name to the case, Mr. Everton Douglas, had been detained for 177 days.
Right.
And his detention was the shortest detention.
Yes.
The longest detention was 495 days.
Right.
So a person in Jamaica was held in detention for 495 days without a single charge ever being laid against him. And the response of the state, when a habeas corpus application was filed, the response of the state was to say that we have detained these men under a state of emergency. And here is the endorsed declaration from the Governor General.
Right.
Under those circumstances, it would be completely illogical, right? And it would neuter the fundamental writ of habeas corpus if the judge, faced with this response from the people who had detained the men, could not actually look into the constitutional issues, because the problem is that the Constitution does actually set out what constitutes an emergency, right?
Yeah, if
and
you
the Constitution is very specific to say that if somebody feels that they have been detained under a declared state of emergency, but that the circumstances as outlined in the Constitution did not exist to constitute a state of emergency, then the court is empowered to determine whether a state of emergency existed. So men had been detained, one for as long as nearly 500 days, and when they were brought before the court via habeas corpus application, the court was essentially told that the state could just detain them because of these declarations of states of emergency. And if the procedural argument was allowed to hold sway, essentially what would happen is that you would basically get rid of the writ of habeas corpus by simply declaring a state of emergency. So the judge had to be able to determine, had to be able to examine whether these declarations comported with what the Constitution said constitutes states of emergency. And he ruled that there was no state of emergency within the meaning of the Constitution.
So I would want you to say for our viewers, if you can recall from off memory, or if you can even look it up, what are those rules? What are the circumstances in which you can call a valid state of emergency?
I'd have to look it up.
Okay. Well, lucky for you, I do have it here. So
help me. I'd have to look it up. I don't remember the wording off the top of my head.
Right. So I see here that a valid public emergency has arisen as a result of the imminence of a state of war between Jamaica and a foreign state, that action has been taken or is immediately threatened by any person or body of persons of such a nature that on so extensive a scale as to be likely to endanger the public safety or deprive the community or any substantive portion of the community of supplies and services essential to life, and that a period of public disaster has arisen as a result of the occurrence of any earthquake, hurricane, flood, fire, outbreak of pestilence, outbreak of infectious disease, etc. So those are the three circumstances that I'm seeing in the Constitution itself. So
when I So when I teach about these circumstances, what I do is that I say to students that you can, when reading it, just as how you read it out just now, you can see why the Constitution says that these exceptional circumstances constitute emergencies. So if you go back and you look at the list, the first one is essentially war or imminent war, right? And so obviously in a situation where the state is at war or is about to go to war with another state, right? The government, the state should have the power to take certain extraordinary steps. The second one, which is the one that I think this government is obliquely seeking to rely on for states of emergency to be used to fight crime, is this one about actions threatened by an organized group that poses that significantly disrupts the life of the community and cuts people off from supplies and whatnot. But if you where you have organized acts of terrorism, things like widespread rioting, that kind of thing. So what the state has tried to do in the last couple of years, right, is to drive the equivalent of an 18-wheeler, right, through a loophole that they think is in that section.
Right.
And what they've said is that if criminality, robberies, murders, etc., go past a certain numerical figure, right, then that automatically activates that section dealing with what I've always read as widespread terrorism, riots, that kind of thing. And they've said on that basis, essentially what they can do is to suspend the usual criminal law process in favor of an emergency powers process under which they don't have to do quaint little things like actually charging people with an offense. And as I say, I point out one man was in lockup, was detained for nearly 500 days with no charge. And so this is what Justice Morrison was faced with when this matter came before him. And so what he did, if people would go back and read the case, is that he did actually assess what constitutes an emergency within the meaning of the Constitution.
Right.
And at the end of his ruling, he said, you know what? There was no emergency situation within the meaning of the Constitution. And we've been having a debate in this country about the meaning of the word emergency.
Yes.
Right? And people have said that, and it's a very effective argument, I must say. People have said, how could you say that 1,900 or however many murders a year does not constitute an emergency, right? And what I would say is that the word emergency as used in the Constitution has a specific legal meaning, right? And so we're not talking about what you or I would constitute an emergency. So that crime being bad, crime being a hindrance to the development of Jamaica, right, isn't in and of itself an emergency within the meaning of the Constitution, because once you have an emergency, the state gets access to certain extraordinary powers that can significantly affect the rights of ordinary people, and those powers, access to those powers, must be tightly controlled. And if you don't have tight controls, what you will get is again a man in lockup for 500 days without charge.
And we would have seen two other rulings coming out with extensive detentions under state of emergency since then. So I want to discuss a little bit the implications of the appeal when we come back.
The new crispy barbecue zinger from KFC. Get ready for a whole new level of flavor. KFC, it's finger licking good. The time by KFC is
1:30.
Open sesame, here comes Rastaman.
So what are you eating? What are you drinking?
Abacadabra, catch me if you can.
What are you reading? And what are you thinking? Join I, Lalabella Gorilla, aka Tony Rebel on Raspirants as we trot on the Bridge 99 FM. Uplifting reasoning to uplift the nation. Tune in to Raspirants every Friday from 10 a.m. until 12 p.m. for a fresh experience on the Bridge 99 FM to the world. Fire Fridays!
Ooh la la. I see what I want at Phosphorus Store-wide Summer Super Sale. Come get your wires, breakers, LED downlights, solar lamps, LED bulbs, standing fans, and so much more. Shop Kingston, Mandeville, and Montego Bay. Come get your smart locks, smart bulbs, video doorbells, and video cameras. You can't afford to miss it. Come shop. Come save at Phosphorus Super Sale. July 3 to August 31. See you there at Phosphorus. Open Sundays.
Hi, I'm Barry Williams, a classically trained baritone, inviting you to an evening with the classics, featuring myself along with renowned soprano Laurie Burnett and other students of classical music. Join me at the Hewitt Chapel Mona on Sunday, July 30th at 6 p.m. for a classical masterpiece you won't forget. Admission $3,000. Tickets available at the Music Mart and Fontana Pharmacies, Barbican and Waterloo. Barry Williams in classical concert. See you there.
The 2023 Jamaica Festival Song Finals are on.
My name is Princess Black, and the name of my song is a Big Up Mama J.A.
All through the time get so hard, and me mind tell me want go abroad. But when me remember me mother J.A., me change me mind and me want an a yard. She birth me, she grow me, she feed me, teach me for me culture and the history. She tell me, say, don't ever forget me roots, cause that go lead to victory. Big up Mama J.A.
To vote for Princess Black, call or text VOTE to 1-876-444-7707. Votes also accepted on the Reggae Jamaica app.
KFC, take it up a notch with the new Zinger. It's got the taste and the flavor, irresistible. Zinger so deliciously, it's on a new level. Crispy barbecue Zinger, love the onion, crisp with the cheddar.
The new crispy barbecue Zinger. Delicious Kentucky fried chicken, bacon, cheddar cheese, crispy onions with smoky barbecue sauce, and a brioche bun. Available for a limited time. The new crispy barbecue Zinger. Get ready for a whole new level of flavor. KFC, it's finger-licking good.
One love, one art, one Jamaica. On the Bridge 99 FM.
Let's start justice. We have been discussing Everton Douglas today. Case coming out of the Supreme Court and recently coming out of the Court of Appeal. And we're joined by Kenyatta Powell, attorney at law. And I would like us to continue our discussion now, Mr. Powell, around the appeal. So firstly, for our listeners, what was the appeal about? What were the points on appeal?
So, essentially, there were two major points of appeal. There were others, but the two important ones were that they were appealing. This is a government now. Appeal on two major points. Well, it's really only one. So the appeal was focused. A central point of the appeal was what we discussed earlier on, which is that they said that the single judge sitting alone in a habeas corpus application couldn't determine constitutional matters. But eventually what the appeal centered on, and I'm going to get into a little bit of technical legalese, but not too much, because I want people to understand, is that the government files an appeal of Justice Morrison's ruling, and the respondents, in this case, would be the the people who were detained and whom Justice Morrison ordered that they were to be released, responded by filing what we call an application to have the case for the government struck out on appeal.
Right.
And what the striking out is that in this case specifically, what the lawyers for the formerly detained men said is that in law the state had no right of appeal for an order, right of appeal from an order given by a judge in a habeas corpus application. And so on that basis, they applied to the court for the government's appeal to be struck out. And what a striking out does is that it ends the appeal without any substantive trial on the nitty-gritty, the grounds of the appeal.
Right.
And it is the point in law that the lawyers for the formerly detained men that they were making is extremely important. So it's not just a technical rule of law.
Right.
It goes to the nature of the writ of habeas corpus, the fact that the state can't appeal the order. So what it is that, as I pointed out, it is a writ of habeas corpus was, one of the more ancient rights arising in the common law, where a free man should be able to quickly challenge his detention before a judge of the higher judiciary.
Right.
And because it is to be quick, and because liberty is such an important right for free persons in a free society, the view at common law has always been that once the judge orders that the person is to be released, that is the end of the matter, and that the state, i.e. the person who did the detention, does not get an opportunity to appeal that order.
Right.
And in Jamaica, that principle is laid out in Section 21A of the Judicature Appellate Jurisdiction Act. And what this act really is that it sets out the parameters, the jurisdiction of the Court of Appeal in Jamaica. And what Section 21A does is that Section 21A grants a right of appeal to the detained person where the habeas corpus application is refused by the judge. That is, the judge decides not to order that the person is to be released. So Section 21A gives the person who is detained the right to appeal the order of the judge if the judge says, no, you should remain locked up. But it pointedly does not give the state the right to appeal if the judge orders that the person is to be released. So the lawyers for the formerly detained men, including our own JFJ board chairman John Clark and Sashika Richards, argued that as a matter of preliminary law, the Court of Appeal simply had no jurisdiction to hear this appeal because the government had no right of appeal. And the court, and in the judgment, the Court of Appeal wholly agreed with the submissions from the lawyers for the men, and it said that it had no jurisdiction to hear this appeal, and that on that basis it struck out the government's notice of appeal, i.e. the government's case in this appeal. But one of the things that the court did do is that the court said, yes, we're striking this out, but one of the main points of appeal that the government had filed was this question again of whether a single judge sitting alone in an habeas corpus application could actually determine, hear and consider constitutional issues.
Yes.
And the court actually went out of its way to rule, I don't say it's a rule, but to actually address that question and said that in appropriate circumstances, a single judge sitting alone in a habeas corpus application can actually hear and consider constitutional questions. And obviously, this case in which the state is claiming that it has a constitutional power to detain these men for very long periods of time without charging them. Obviously, in this case, on a habeas corpus application, the judge sitting alone clearly had to actually consider and pronounce on those constitutional issues.
So, coming out of the judge could, in the circumstances where the circumstances are available, rule on this speak to this constitutional issue. The court has now affirmed this. Does this mean anything for the continued calling of state of emergency? I believe we've had maybe more than 3 already called this year. So I'm curious as to your legal opinion on that.
You see, for me, it's not necessarily a question of the legalities anymore, because we've had after Everton Douglas, we had Rasheen Clark,
yes,
and then we had one more recently,
Kurt Mitchell,
right? Yes, and it seems to me that if you look at the sort of security architecture that the government is trying to create in relation to the use of emergency powers, it seems to me that we have now had 3 cases that have significantly cast doubt on on the setup that the government has tried to implement in relation to these emergency powers.
Right.
So I think one of the reasons, for instance, that the Everton Douglas case was appealed, right, despite the fact that it seemed clear to a lot of us that the statute simply did not allow for the government to appeal it. So I think one of the reasons that the government appeal it is how strong Justice Morrison was in that case in actually examining the constitutional matters, right?
Yes.
And handing down a ruling which cast serious doubt, right, on what the government was doing. And one of the things I found myself doing over the years is reading for people what Justice Morrison said at the end of the case,
yes,
right, in his written judgment. And he says, in the final analysis, I am unhesitant in holding that one, a single judge has the jurisdiction to entertain this application pursuant to the court's inherent jurisdiction and section 21 of the Constitution. Right?
Yes.
2, and this is the important thing. 2, the situation which led to the detention of the objectors does not qualify as an emergency or satisfy the situation set out in sections 22, sections 20 subsection 2, section 20 subsection 5, or section 20 subsection 5 of the Constitution. Those are essentially the emergency situations you were reading out just now. And then he said at 3, the claimant's constitutional rights and the Constitution itself is being breached by the current detention and what Justice Morrison called the executive detention system. And so what he did is that he said in the case that it appears to me that what the government had done, right, is to create an executive detention system outside of the normal court, the normal criminal justice system, because what they kept saying is that these men are suspected of committing crimes.
Yes.
And so the answer to a claim that you have detained a person that you suspect of committing crime or committing a period, you should charge that individual, right? And once you charge that individual, that triggers an entire criminal, which you, the person who has laid the charge, is now required at a certain point in the process to prove the allegations against the detained person beyond a reasonable doubt. And after being charged, the detained person now has the ability to apply to the court to be granted bail while his case is going through the court system. And what Justice Morrison found is that essentially the government was going around this system with all the rights and protections for people who had been detained, and was using the states of emergencies to create what he called an executive detention system, in which the government of the day was simply allowed to decide who it wanted to lock up when, and be able, with just the declaration of states of emergency, to lock up these people for extended periods of time, not charge them with anything, and these people would essentially be cut off from the normal criminal justice process. And Justice Morrison said very clearly that kind of setup, that kind of scheme, that executive detention system was not just violative of the rights of the people who were before him, but he said that system violated the Constitution itself. So I think what was at play in this appeal, right, was really an attempt to relitigate the issues that Justice Morrison
already
set out, already ruled on in the Court of Appeal, in order to wash it away, in order to say that the conclusions that Justice Morrison came to in relation to the constitutional issues were fundamentally flawed. Because I think if we accept that Justice Morrison was correct, that what they were doing was violative of not just the rights of the men, but the Constitution itself, that there was no emergency within the meaning of the Constitution, that those kinds of conclusions directly impugn the crime-fighting scheme that we can say at this point in time this current government is seriously committed to implementing in Jamaica. So I think that's why we had this this appeal that, in my estimation, more likely than not, would have ended up the way it ended up.
You know, as we talk about the government's intentions to address the crime issue, one of the things coming out of late last year was the Bail Bill 2022 that would have included some justifications under its memorandum of objects and reasons to crime fighting, and would have also included new provisions for pre-charge detention, something which JFJ was completely against in our submission. So I wonder how, in your estimation, if any way, the pre-charge detention in the bail bill kind of mirrors what is happening here with the state of emergency.
So it mirrors it, but it's not a perfect mirror, because pre-charge bail is still bail, right, so that it is slightly better, because at the very least the person in question has a greater opportunity to not be locked up.
Sure.
The problem with pre-charge bail is that it comes from the same, it springs from the same root that the government's use of routine use of states of emergency springs from, which is the idea that the executive should, on a routine basis, be allowed to impugn the liberty of ordinary people, right, without having to charge them with an offense. Right? Because you haven't been charged with anything, right? Yet you have been granted this pre-charge bail, and then the pre-charge bail comes with all can come with all manner of conditions, including reporting conditions, confiscation of your travel documents, etc. Right? And then if you breach the conditions of your pre-charge bail, that itself constitutes a separate crime. So that again, you're seeing the same kind of approach of significantly infringing on the right to liberty of the ordinary citizen without again, having to go through this pesky thing of charging the people with an offense. So I put them in the same basket. I put them in the same basket. The use of the state of emergency and pre-charge bail, and I would seriously advise the state against going down that road. But I think that if you look at what's happening, the state is committed to this, to what they're calling bail reform.
Yes.
I don't think I think reform is a bit of a misnomer in relation to what they're trying to do. They're not so much trying to reform the bail statute as they're trying to impose ever more limitations, restrictions on the right to bail, which is, by the way, right specifically enumerated in the Constitution, in the Charter of Fundamental Rights and Freedoms. So we have to be vigilant, right? And we have to be clear about what our positions are in relation to these to these kinds of schemes, and we have to be organized in a way to ensure that not only our voices are heard, but that we can actually, impact this kind of legislation and policy making in the direction of respecting human rights.
Well, thank you so much, Mr. Powell. That was a nice to tie up there. I want to thank you for joining us this week and having this discussion with us. And of course, we will have you on later on other episodes. So thanks again.
Thank you, and thank you to your listeners.
As you know, JFJ would have been. So that was Mr. Kenyatta Powell, attorney at law, a member of JFJ's board as well, discussing the Everton Douglas first case and appeal. So we are winding down to the end of the show now. I do want to remind our listeners, as we just had our discussion around the bail bill 2022, that the bill will be tabled. Its revised version is planned to be tabled today, as well as the report coming out of the Joint Select Committee. So we look forward to seeing what the recommendations that were taken are. As you know, JFJ would have made submissions on this bill. We discussed some of our key points in an earlier episode of Let's Start Justice that you can access through our YouTube channel at Jamaicans for Justice, as well as some key points coming out of, some key concerns actually coming out of the bill that we would have posted on our Instagram. So please interact with those if you want to be more informed. Today in Parliament, we are also to see the tabling of the new, hopefully revised Section 24 replacement to the Child Care and Protection Act, that is to replace the issue of uncontrollable children. Another thing that we discussed on the show, I believe we discussed that last week or the week before last. So we look forward to seeing what that updated proposal looks like. And unfortunately, we do not have a winner to our trivia. We have an attempt, but we don't have a winner as yet. So we will keep the competition open for the remainder of the day. Should the person correctly answer first, of course, you win your credit. So we will look out for that. So we're at the end of the program now. Thank you so much for joining us. I am Jade Williams, Policy and Advocacy Specialist at Jamaicans for Justice, and we'll be back next week. Well, next week we're on holiday, so we will do a rerun next week, and we'll be back the following week with a new episode of Let's Start Justice. So thank you so much, and we'll see you then.
Justice for all, justice under law, justice, Jamaica belong, right to life, right to liberty. Out of many we are one in Jamaica, make it a better place for the boys and girls. Create the equal by the creator, for equal rights and opportunities. No to unlawful detention and police brutalization, class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or Jamaicans4Justice.org.
The people's champion.